Happy New Year to all of you, and welcome to our very first or seminar class or lecture, the second semester of our company law. So we are starting with the law of corporate finance, and this will involve discussion of the various means by which the company raises capital or the company is capitalized. We'll be discussing shares, we'll be discussing loan capital, and the various rules, principles, and doctrines associated with this financing mechanism, and how they also uh, impact on governance of the corporate entity. So I'd like you to read chapters 16 and 22 of Mr. Ferdinand Adadzi's work, Modern Principles of Company Law in Ghana, and relevant provisions of the Companies Act. And very soon, we will go back to the text of the law itself, and we'll be discussing the whole of Part F, Part G, Part H, and later Part I, and Part J of the Companies Act 2019, Act 992. So to start with, what is capital? Is useful to explore how capital is conceptualized before we delve a little bit deeper into the nuances or the details of the rules. So the word capital means different things in different contexts. So that is the first point you should know. In a sense, it's a bit like the chameleon. It's probably assumed the color of the environment in which it found itself. So capital can be thought of in physical terms, so that when you are looking at the factors of production, from basic economics, if you like economics 101, we are told the four main factors of production, the things which are needed for production to occur, include capital. So therefore, capital conceptualized in physical terms becomes a means of production. Also, it can be seen in value terms or in money terms. So capital can mean different things. Now, what is the modern legal concept of capital? When you go to the realm of, let's say, taxation, we talk of the distinction or the dichotomy between capital and income. So for purposes of determining what should be taxable, what should not be taxable, what tax rate or regime to apply to what, it will depend upon how a particular earning or particular thing is labeled or characterized. If it is characterized as capital, the treatment of it for purposes of taxation is different. In the same vein, if it is characterized as income, it's also treated differently. Now, when you come into the realm of company law, which is the subject area of our present interest, capital covers a number of things. Capital covers share capital. So share capital refers to the funds subscribed by members, to members of the company, especially when we are dealing with the company limited by shares. The funds which have been generated from the members, from the shareholders, the subscribers, will constitute the share capital. Now, after this general introduction, we will zoom into the specifics of the law itself when we start discussion of Part F of Act 992, starting from section 42 and related provisions. Again, in company law, capital covers what we call loan capital. That is the fund provided by maybe commercial finance providers and other investors holding debentures or debenture stock. So, or what we call like the borrowed capital, loan capital or borrowed capital is another sense in which the word capital is deployed in company law. Again, in company law, all funds, whether provided by members, creditors, or by way of retention of profits, as you come to learn later on, what you call a bonus issue or capitalization issue, where instead of distributing dividends, which will have been returns that shareholders are earning on their various investments, those are retained or plowed back into the operations of the company. So that is also another form of capital asset. Well, again, in company law, if we look at the authors of Farrar's company law, they will let us know that another sense in which capital is deployed is the assets in which all funds have been invested. So the aggregate, the totality of funds invested in the assets or the assets in which the funds are invested also constitute another sense of capital. Now, in terms of financing the company, what options are available to the company? Last semester, we saw how compliance with the registration requirements under Act 992 would enable an incorporated entity called the company to come into existence and is signified by the issuance of certificate of incorporation, and realize that the incidence of incorporation or the legal consequences of the company having come to existence include the fact that it has perpetual succession, it has a separate legal personality, it has capacity, like a natural person. It can enter into contracts, it can incur liabilities, it can assert rights. And as you remember from the locus classicus on the subject, Saruman and Saruman, all these points were actually underscored last semester. So now we have the company in existence. How do you provide capital? How do you provide funds for the company to run? What are the financing options available to the company? Well, the financing options available to the company would include so how do you raise capital for the company? What resources are available to the company? Oh, goodness. Please hang up. I'll call you back. I'm using the phone for teaching. Thank you. Sorry, I'm using my phone for hotspot. So when there's a call, it distracts the internet connection. Well, there are various ways in which the company may raise resources for its running. And These ways, if I am to open the lines, among other things, you talk about the fact that the company can raise capital by giving out shares. The company can go and borrow. The company can plow back profit, as we have seen, and so on and so forth. Another point worth noting at this preliminary stage is that those of you who will have bothered to look at the repealed companies legislation at 179, particularly sections 27 and 28 thereof, you have noticed that under the repealed law, a company duly incorporated, which was limited by shares, needed to meet what we call minimum capital requirement. And if the minimum capital requirement was not met, the company could not commence business. The company could not transact, and it could not actually start incurring liability and asserting rights under transactions. But one of the major changes under the new Companies Act, Act 992, is that it is no longer mandatory for any threshold or minimum capital to have been raised before a company which has only been incorporated can commence business or transactions. So let's keep that in mind. Nevertheless, the point needs to be made that for certain types of companies in certain industries, especially if you are dealing with the Ghana Investment Promotion Center Act, for example, Act 865, for certain types of businesses, certain types of trading or investment, the law prescribes minimum capital or minimum investment before the investor could proceed. So that one is different from the general company law requirement, which used to be the case under the repealed at 170 now. Under the current general company law of Act 992, there is no requirement for minimum capital. So let's keep that in mind. Again, if you look at companies operating the business of banking under the auspices of the Banks and Other Specialized Deposit-Taking Legislation of 2016, Act 99, it is a requirement that a certain amount of capital should be raised, what do you call like the stated capital. So if you are investor bank, you're probably supposed to raise by maybe about, let's say, 400 million Ghana cedis, for example. If you are savings and loans, probably 100 million Ghana cedis, or the amount as stipulated by the Bank of Ghana. If you're a rural bank, probably 1 million or something like that. So not until you raise that, you will not be given the license. Or if you had a license and your stated capital has fallen below that, sanctions will be imposed on you. But those are just exceptions, not the rule. Good. So what are the means of raising capital? Companies raise funds through, first, the issue of shares, as we talk about, and we call that equity, right? So maybe in accounting terms, when they say equity, they are referring to shares. But of course, as we move on to discussion of shares proper, you will notice that equity shares is also a particular type of shares in contradistinction to preference or preferential shares, but we come and discuss that. So company raise funds through issue of shares or debentures. So debentures simply refers to loan. The company borrows or takes loan, or the company will raise funds through a combination of shareholders' money and also borrowing, or it could go either way. And as we have also indicated, the company could also raise funds by flying back profits, especially if the entity is a going concern, meaning that if the entity is able to pay its debts as and when it falls due. And this reminds me of a certain matter which came up recently in the court. In a particular case, some creditors have actually triggered the liquidation process, official liquidation under the Corporate Insolvency Restructuring Act against a particular company for the reason that the company is owing it, and then the company has defaulted in paying. Then that company put up defense in the court and says that the quantum of indebtedness, how much is being owed, has not properly been determined. And for that matter, it's a premature for the creditor to jump to the conclusion that it is unable to pay its debt. So therefore, it should be liquidated in accordance with the prescriptions of Corporate Insolvency and Restructuring Act of 2020. And that is why the point is being made that before the company can plow back profits, then the company must be a going concern. It should be able to pay its debts and liabilities as they fall due. And that would also mean that you are going to transfer money from the reserve to the stated capital in accordance with Section 68 of the Companies Act 2019, Act 992. So let's keep that in mind. Also, raising of capital through shares is possible for only limited, company limited by shares and unlimited companies. So if you look at Section 7, subsection 3 of Act 992, it's quite explicit that it is only company limited by shares that can raise funds, that can raise capital through the issue of shares, as well as unlimited company. But company limited by guarantee cannot do that. So let us keep that in mind. So certainly, you appreciate that the capital is the very life wire or the lifeblood of the company. So without it, it's not possible to actually run affairs of the company. So in what way would the company be able to raise shares? The company may raise shares. Now, just before we move on to look at this, remember when we're discussing types of company, we talk about private company and public company as one important way of classifying companies. Now, one of the important criteria for drawing the distinction between a private company and an unlimited company in terms of Section 7 of Act 992 is that in the case of private company, it is prohibited from making invitation to the public, meaning that it cannot call upon members of the public to subscribe for its shares, to invest in it, as it were. On the other hand, a public company can make invitation to the public So it can make public offer of shares, and here the company will sell shares to the public who are members of the public interested, and that way capital is raised. And how are the members of the public made aware? The members of the public may be informed through media and other advertisement that shares are available for subscription by those who have got idle funds to invest. So the public will make offer or accept offer made by the company as the case may be. So you sometimes hear of the IPO, initial public offer, and that is done by a newly incorporated company or a private company which is converted to a public company, or where a company is on the threshold of being admitted into a licensed stock exchange. Some of the stock exchanges, it may be a requirement that you should have a certain threshold of capital. So you are challenged to make, let's say, your initial public offer and then see how much response you get. And that may probably be a factor in making a decision as to whether you'll be admitted to have your securities or your shares traded in a particular stock exchange, as it were. Now, public offer of shares can also be made through placement, by which intermediary, such as bank or brokerage firm or insurance companies, either take the whole of it, its shares or part thereof at agreed price. So the company has a certain number of shares, okay? And you can get a company called the brokerage firms who serve as intermediary and say, okay, we are going to pay this amount of money to you upfront and take the total shares that you have available. And we, in turn, are going to take our time and retail them or sell them to those who are interested at the price that we will determine. So that may also be done as the case may be. Or it may well be that maybe you said, okay, this is going to be sold for 1 cedi per share. That's what we are thinking now. And the brokerage will say that if you let us take one share for 70 pesos, then we are prepared to pay everything to you. Meaning that later on, if the intermediary or the brokerage is going to sell to third parties, they'll be making commission of, let's say, 30, 30 pesos, as it were. But then later on, when we are discussing the doctrine of capital maintenance, you will notice that there are restrictions regarding how much commission could be given to brokers. And that, among other things, should not exceed 10%. So we'll look at that later on. So, what are the advantages and disadvantages of public offer of shares in terms of what we have explained? Are there some advantages in using this option to raise capital? I'll take a one male, one female, and I'll move on. Raise up your hand and I will release your mic. Since you are not prepared to speak, I'll continue. Boss, your boy. Okay, let me see if I can get you. Yes, Amos.
Hello, my lord.
Yes.
Good evening, my lord.
Good evening.
Yeah, good evening, colleagues.
Good evening.
My suggestion with the advantages of the public offer share is it may give the opportunity to members of the company to at least first apply for, get a chance to whether to buy the shares or not. And one of the disadvantages is with the middleman that comes in between the company and the buyers of the shares might create a lot of increase of, let's say, amount of money used to buy the shares. At least there might be an increase of prices per share if it might be like the individual is supposed to buy it directly from the company, please.
All right. Thank you. Yes, now the female. Okay, Emmanuel Brobe. Emmanuel Brobe, a female now. Okay. Emmanuel, you can release your mic since you want to be treated as a female.
Yes. My Lord, good evening.
Good evening.
Hope you are doing good.
Yes,
Happy New Year to you too.
many happy
Been a
returns.
long time.
Yes. Mhm.
Okay. And thank for the opportunity.
Thank you.
Please, one advantage that I will also say about public offer of shares as an option for raising capital is that the access of large capital. You see, when public or come together to offer shares, the company or get an opportunity to also raise a substantial funds from wide range of investors. This also help. And one disadvantage that I can also add to it is that it also creates a pressure to perform, since public companies face pressure from shareholders to also deliver short-term profits, which may conflict with their long-term strategic goals. So one advantage and disadvantage that I can also say is what I've also given. Thank you very much.
Thank you, friend Brobe. Yes, just before I leave, can I hear one female voice? Move on to the next. Yes. We have female vice president, so now the women have to be more active. Soon we'll be getting female president. The first two females were with, but none of them is minding me. Right, proceed. Okay, Elizabeth. Okay. Lazy. Where is the yes. Elizabeth, you can unmute.
Yes, yes. So I can talk about one disadvantage that the
Right.
IPO process is cumbersome and
Your line is breaking.
Time consuming because you have to show that you're meeting all the strict rules and regulations. So to get it right. So yeah, that's one disadvantage I can say
Right.
about that.
Right. Thank you. Well, we also have a private placement of shares, and this involves direct offer or invitation to particular investor to acquire shares of the company. So you can target particular investor or group of investors, as it were, to come and acquire shares of the company. Probably what you may call like a strategic investor, so to speak. And private placement of shares is very useful to private companies because if you look at Section 7 of Act 992, they are prohibited from making invitation to the public. And that is why they could take advantage of a private placement. And in that case, the requisite resolution may be passed, and whatever offer is being made will be considered by the board and then probably like the general shareholders that they agree that this particular person should be allowed to subscribe for a certain quantum of shares. Of course, private equity firms also bring investors and companies seeking funds together. So we have like equity firms out there whose business is to serve as a platform looking for investors that have got money to actually invest, and companies that cannot really, let's say, make public invitation as we've discussed, but are also in need of money. So private placement enables that to take place. And what do you think are some of the advantages and disadvantages of the private placement of shares? So let's take a one male and one female and then we move on quickly. I want us to be fast. We have a lot of grounds to cover. Yes, anybody? Yes, Mr. Brobe.
My Lord,
Just before Mr. Brobe continues, I'm going to open my special book to take note of those who actively participate in class so that I'll use my discretion as far as the continuous assessment to give them additional points. So proceed, Mr. Brobe. Mr. Brobe, proceed.
Okay, so my Lord, one advantage that I can talk about the private placement of shares is that it's faster and less expensive as compared to a public offer of shares. Because the people are few, so decisions and regulatory requirements does not take much time, unless the public one, which consensus must be met by so many people from different places. So I think the private placement of shares is faster and less expensive. One disadvantage that I can talk about is the advantage that I mentioned in the public offer of shares. The disadvantage is that it brings up limited capital. the capital that they are able to offer are so limited. Since this one is private placements of shares as compared to the public shares. So these are the advantage and the disadvantage that I can also give under this topic.
Right. Thank you, Emmanuel Brobe. So let's take Nathaniel. Nathaniel?
Thank you, sir. Hello, sir. Can you hear me?
Yes, please proceed.
I think I'm looking at one of the advantages is the confidentialities. The companies can keep their financial and operation details more private, and thereby avoiding the need to disclose extensive information required in their public filings. I think that's what I can say on that. Thank you very much, sir.
Well, thank you. So what I'm doing in my special register is that once you contribute, your name is written down. If you contribute again, I take one. As many times as you contribute, I keep taking, so that when I need to take a decision, then I'll decide how many marks should be allotted for each taken. Any female? Yes. Queer. Queer, what is your full name? Queer, you can unmute. Yes. What's your full name?
My Lord, I'm Anita Donko.
Okay.
Good evening.
Good evening.
And my Lord, please, one disadvantage I will give to the private placement shares is that they have limited access to capital, because the number of investors that go into private placements are limited. So therefore, the investors that come into that company are not much. So the capital that they are supposed to use for their company is not as large as that of the public companies. Thank you.
All right, thank you. We have Juliet Kunedu Boachi Yadom. Yes, Juliet.
My Lord, good evening. Please, one of the advantages is that it is fast or is quick, since the invitation is to a particular investor.
Very well. All right. Yeah. And we also have another financial option known as right issue. So right issue basically consists in issuing shares to existing shareholders in proportion to their existing shareholding. So if we look at the section 189 AI of Act 992, it provides for that yes, you may give existing shareholders shares which are proportionate or fractionally equivalent to their present shareholding. And the idea, obviously, is to maintain the balance of shareholding and then the rights and also the power which shareholders exercise when it comes to decision making. As you will notice that in terms of vote, as a rule, one share carry one vote. So sometimes you may want to maintain the balance of voting rights and other privileges. So you give existing shareholders proportionate number of shares And right issue may be renounceable or non-renounceable. It is said to be renounceable where the shareholder acquires the shares issued or trade the right to acquire the shares by assigning it to another person at a price. So we are giving the shares to all existing shareholders. If you have, let's say, 1.5% of the shares, the number of shares we are going to give will be to that extent. However, if it's indicated that it's renounceable, what it means is that once you get it, you can also assign or transfer it to another person, so that another person will rather acquire that which ought to have been yours by reason of being an existing shareholder. A right issue may also be non-renounceable. It may also be non-renounceable. That is to say that it prevents the holder from renouncing and assigning it to another person. You keep it and you cannot give it to another person, as it were. So in that case, if you probably don't want it, then you don't get some at all. So open, we also have like open offer arrangements, which will be made to enable existing shareholders buy shares at a price lower than the prevailing market price. Depending on how well the company is performing, the demand for A shares may be so high. And don't forget that the basic principles of economics, demand and supply, which determine prevailing market price, also apply mutatis mutandis when it comes to fixing the price of a share. So therefore, the price which may be paid for shares on the open market may be higher, but for some other appropriate reasons, existing shareholders under special arrangement may be giving shares at the price lower than the prevailing market price. Now, what do you think are some of the advantages and disadvantages of right issue generally? Yes, what are your thoughts? Must voice your hand up. Yes, anybody?